My name's Ken Swinton. I am a council member of the Scottish Law Agents Society, and this CPD presentation is about Japanese knotweed and conveyancing practice here in Scotland. I think at the time of recording this, it's a timely presentation, given that there have been two recent cases in connection with Japanese knotweed, one in Scotland in Edinburgh Sheriff Court, and the other a couple of months ago in the Supreme Court. First of all, I think we should discuss what Japanese knotweed is. It is an invasive non-native species to the United Kingdom. It has attractive stems in red, green leaves, and a root structure with rhizomes, which strictly are not roots. But the rhizomes can spread laterally, and if not controlled, will continue to spread and spread and spread. These rhizomes and new knotweed plants can cause damage to things such as footpaths, drives, patios, garden walls, and fences. And it has become quite well known that it is difficult to eradicate. There seems to be almost a hysteria in relation to Japanese knotweed, but recent research has demonstrated that it is only in the very exceptional case that the structure of a house itself will be damaged. The reason for this is that the rhizomes and root structures of the Japanese knotweed tend not to exceed 70 centimeters in depth. The foundations on a house typically exceed 70 centimeters on depth, so the knotweed cannot pass beyond the foundations and get into the structure of the property itself. Notwithstanding this, and there seems to be a significant amount of comment in national press, in popular press at least, about the impact of Japanese knotweed and other invasive species, which I'll come to later, on the desirability of owning the home, its impact on the ability to sell, the value which can be obtained for sale, and the willingness of lenders to lend on a property where Japanese knotweed is present. There may also be impacts on home insurance. So generally, a purchaser will be unlikely to proceed with a house that is known to suffer from Japanese knotweed. So here we have a picture of Japanese knotweed, and you can see that it's damaging this thin layer of concrete, I think it is, and we've got structure pursuing weak spots in that concrete with the rhizomes and planting round about it. But you'll note the wall behind looks a substantial wall, and it doesn't appear to have been affected at all. So if we turn to the Scottish Standard Clauses, 5th edition, 2.1 provides awareness of circumstances, and the general words at the commencement of 2.1 relate to Japanese, relate to a variety of things. It provides, so far as the seller is aware, but declaring that the seller has made no inquiry or investigation into such matters, the property, including in respect of clause 2.1.3, the building, if appropriate, is not affected by Japanese knotweed in 2.1.4. So there's something there that we need to look at. Firstly, there are separate definitions in the Scottish Standard Clauses of property, which extends to the whole property, and in 2.1.3, the building. So if 2.1.3, which I'll come on to in due course, deals only with the building, then it's a more restricted provision. And I'll come back to that, as I say, in due course. The reference to Japanese knotweed was not included in Scottish Standard Conditions version 4 or any earlier edition of the clauses. Recent case law, which I'll touch on shortly, suggests that notwithstanding the omission of 2.1.4 from Standard Conditions version 4 and earlier of Japanese knotweed, notwithstanding this, Japanese knotweed was already covered by 2.1.3, the clause relating to wet rot, dry rot, rising damp, etc. So I think there are two questions. One, if 2.1.3 could cover this situation, why was there a need for 2.1.4? Our alternative view on that is that 2.1.4 was included because the drafters of the Scottish Standard clauses thought 2.1.3 did not cover Japanese knotweed. And why Japanese knotweed and nothing else? And why now? And why not earlier? So there's a whole series of sub-questions that arise. The recent case that I have mentioned is Busby and another against Blair and another, 2024 Sheriff Court, Edinburgh 24. Busby, the purchaser, purchased Firth Lodge, Auchentinny, Roslin, to the south of Edinburgh, described in the sales particulars as a converted and extended lodge house with over 2.5 hectares of ground, which was sold to the Busbys at a price of $602,500 with entry on 21st May 2021. And looking at the house, it looks to me like a new build property from the exterior, and exactly where the original coach house is difficult to ascertain. Yeah, the 2.5 hectares of ground seem to be rough ground, sloping down towards water, running water at the rear of the property. Well, in Busby, the pursuers discovered the presence of Japanese knotweed on the property and raised action against the defenders based on Standard Conditions, version 4, 2.1.3. So, insofar as is relevant, 2.1.3 provides, so far as the seller is aware, other than as disclosed in the home report for the property, any structural defects. So the defect must be to structure, wet rot, dry rot, rising damp, or penetrating damp, woodworm, or other infestation. The defenders in their pleadings admitted that they had been aware of Japanese knotweed on the subjects, had previously sprayed and trimmed it. The debate centred on whether Japanese knotweed was in fact in contemplation of the parties in the wording of 2.1.3 when the contract was formed, that is, at the time of offer and acceptance. And the pursuer's argument was that the general words are sufficiently general to cover the situation. The defenders argued that other infestation should be construed eustem generis to the other items in clause 2.1.3, namely structural defects, wet rot, dry rot, rising damp, or penetrating damp, or woodworm. So that was the argument. It was quite a tightly focused argument. I had a look at Standard Conditions version 5, and all earlier versions include the form of words in 2.1.3 or other infestation. When I look back at antecedents to the Scottish Standard clauses, the main progenitor of which was the Edinburgh and Glasgow combined clauses of 2013, I discovered that those combined clauses did not include the words or other infestation, and earlier regional missives omit any provision except Highland clauses in 2007 and the Tayside clauses, which I traced back to 1992 and did include similar sorts of words. So I wondered if, in fact, woodworm was the explanation. There is a common perception that woodworm refers to the common furniture beetle. However, looking at a variety of sources, it seems that no species can be identified as woodworm. Rather, woodworm is an explanation or description of the phenomenon of wood-boring insects boring into wood, rather than identification of any specific creature. So strictly, there was no need in the Tayside example from 1992 to include or other infestation. But I am aware that in the Dundee area where the Tayside clauses first appeared, there had been issues where it had been argued that the woodworm was not common furniture beetle, therefore it fell out with the term woodworm. But that clearly was an incorrect argument. There was no need to include or other infestation or other insects, other wood-boring insects, or some similar wording in standard clauses. So when I was preparing this talk, I began to ask myself the question, why knotweed? Why Japanese knotweed is singled out for special consideration in 2.1.4. And here we've got a couple of examples of property which is affected by non-native invasive species. On the left, we have a building affected by Buddleia, which is growing around a window. And Buddleia is well known to cause potentially structural damage because of the woody nature of its stems, which can expand into a crack and expand the crack, causing water penetration, all sorts of further damage as a result. And on the right, we have a picture of bamboo. And here we can see bamboo in the middle of a house. This was a story which appeared in the popular press, and it appears that the tenant of the other semi-detached house kept bamboo plants in a pot. The pot had holes in the bottom for drainage. The roots and rhizomes of the bamboo broke through the floor below and spread sideways to the adjacent property, reappearing under the floor and eventually breaking through the floor of this poor homeowner's property. So why only Japanese knotweed? Why not Buddleia and bamboo? Both are non-native species, both are known to be invasive, and both are known to cause damage to property. Well, Japanese knotweed is listed as an invasive species under Section 14 and Schedule 9 of the Wildlife and Countryside Act 1981, as amended here in Scotland by the Wildlife and Natural Environment Scotland Act 2011. And Japanese knotweed alone of these three is listed as a controlled item of waste under the Environmental Protection Act 1990, making it an offence to sell Japanese knotweed plants, and secondly, to transport any Japanese knotweed plants or affected soil without a permit from SEPA for that purpose. So it seems to be singled out in legislation. It's been known about for over 40 years, and yet only in the latest edition of the standard clauses do we find a reference to Japanese knotweed. I want to speak now about the significance of the first guidance issued by the Royal Corporation of Chartered Surveyors, which was issued in 2012. This was issued as guidance to assist valuers in assessing the value of a property where Japanese knotweed was present. So that in itself was 30 years after the scheduling under the 1981 Act and over 2 decades after the listing under the Environmental Protection Act 1990 as controlled waste. Clearly, it had been an issue for 40 years by this time, and it seems that the surveying profession was only just catching up. It offers a fairly pessimistic assessment of the problem with Japanese knotweed, and it influenced lenders to include restrictions in loan instructions on lending on properties affected by Japanese knotweed, which of course affected the saleability and mortgageability of those properties, and that had a direct impact then on property prices affected by Japanese knotweed. As a result of this guidance being issued, we can see in subsequent litigation that this has become a terminus a quo for claims. And if we think that through, it also becomes a terminus a quo for the limitation of those claims. The first significant case involving Japanese knotweed was a case of private nuisance. Now, although one of the bodies in the case, the appellants Network Rail Infrastructure Limited, are public body, it is nonetheless a private nuisance case. Williams owned a property in South Wales, the rear boundary of which backed on to a railway embankment owned by Network Rail. The parties agreed that Japanese knotweed had been present on that embankment for at least 50 years. That's the quote from the case itself. That admission meant that nuisance had been present when Williams bought the property around 2001, although it doesn't appear to have occurred to the parties to the action that he came to the nuisance and that liability in nuisance should start running from 2001 when the property was bought. The case proceeded from the local courts to the Court of Appeal in England, which held that the appellants were fixed with actual constructive knowledge that Japanese knotweed was a significant issue, and the spread of which was something which owners of property ought to prevent as a result of the issue of that RICS guidance in 2012. So from 2012 onwards, Network Rail came under a duty to take steps to prevent the Japanese knotweed spreading. The Court of Appeal held that they were liable to the respondents for the pure economic loss, which was measured by the diminution of value of the property with Japanese knotweed compared with the property without Japanese knotweed at common law nuisance, and that liability was not abrogated where treatment had been completed on the rear garden of Williams' property and on the adjacent embankment, which seems to me somewhat harsh. The most recent case to come out of England is Davies against Bridgend County Borough Council, 2024, UK Supreme Court 15. So Davies had purchased his property in South Wales in 2004, again years before the RICS guidelines. his property backed onto a council cycle path, which may be, in fact, a disused railway line, although that point isn't clear from the case itself. Again, it was an agreed fact that Japanese knotweed had been present on the cycle path and the back garden of the property at the time Davies purchased it for many years. In this case, however, the Supreme Court allowed the council's appeal, holding that any diminution in value had occurred prior to Davies' acquisition of the property in 2004, and therefore he was limited from raising an action. It was well before the 2012 guidelines. However, the Supreme Court accepted that constructive knowledge of the guidance would apply to landowners who would come under a duty at common law to treat knotweed so as to prevent its spread to adjacent properties and thereby prevent nuisance at common law occurring to the detriment of adjacent proprietors. So this idea of coming to the nuisance and limitation applying from the 2012 guidance has severely restricted the ability of homeowners to recover for the diminution in value against public authorities such as local councils and Network Rail. Sorry, I just skipped up there. A question that we should ask is the reputation of Japanese knotweed justified? Now, in 2022, RICS issued new guidance, Japanese knotweed and residential property, which superseded the 2012 guidance. And later on in 2022, RICS reissued this same guidance in identical terms as a professional standard. So surveyors now must comply not only with guidance, but with a professional rule that requires them to comply with the terms throughout of this guidance. I thought it was quite interesting, however, that paragraph 4.1 of this revised guidance, now professional rule, states that research has demonstrated, and it is now generally accepted, that Japanese knotweed poses little or no risk of structural damage to robust buildings with substantial foundations, such as dwellings, as opposed to less sturdy structures with shallow foundations, such as conservatories, garages, or boundary walls. So we are perhaps getting overexcited about Japanese knotweed. And that's borne out by a report by the Department of Environment, Food and Rural Affairs, DEFRA, in 2017. And that DEFRA report states attitudes are currently disproportionate to the physical risk posed by Japanese knotweed. Furthermore, the media, as a result, the public, have a disproportionate fear of the problem. And there's a long section on how it can be remediated, it can be cut back, it can be sprayed with industrial strength glyphosate, and in severe cases, the soil can be taken away for incineration by a suitably qualified contractor. And there are a number of specialist contractors that you can find if you simply Google knotweed removal Scotland. Public perception fueled by popular newspapers remains otherwise. And I think it's notable that SEPA in Scotland has neither adopted the DEFRA report 2017 or carried out any research of its own. I've taken this map from the site of a company called Environet, which claims it is the leading specialist removal firm for Japanese knotweed. And this is its postcode search map for the central belt of Scotland. And they've described it as a heat map. So no colour or green colours show very low incidence of knotweed, and orange and red colours show greater concentrations of Japanese knotweed. So there seem to be concentrations in the Glasgow conurbation and in the Edinburgh conurbation, another hotspot in Aberdeen, and for some reason around Fort William. Now, of course, these heat maps produced by Environet are based solely on the locations of properties where Environet have been called in to give advice and carry out appropriate treatments. I should have mentioned before I go back to Busby and another that one of the Environet treatments is to dig a trench more than 70 centimetres deep, line this with an impervious barrier to prevent the rhizomes penetrating through it and backfill it. And this prevents the further spread of Japanese knotweed. Well, to go back to the case in Edinburgh Sheriff Court, the defenders argued or other infestation should be construed eustem generis. And for the reasons that I've explored earlier, I think the or other infestation was included in the standard clauses to cover situations of infestation by insects other than common furniture beetle, which caused woodworm. The pursuers looked to dictionary definitions such as Collins' Contemporary Dictionary, and after the debate had taken place, Sheriff Pino de Amidio took comfort from reading Gretton and Reed's Conveyancing, to which it doesn't appear he was referred earlier, in particular paragraph 4.24 of that book, which says infestation, an offer will typically require the sellers to warrant that so far as they know, the property is not affected by infestations such as wet rot, dry rot, damp, or woodworm. Now, when you look at that, that means that they have in fact restructured the order in which the clause 2.1.3 has been assembled, and other infestations appear at the end, and in my view, were designed to qualify woodworm only, and not wet rot, dry rot, or rising damp. In the third edition of Gretton and Reed, the paragraph which corresponds to 4.24 is 4.21 and is headed rot. An offer will typically require the sellers to warrant, so as far as they know, there is no timber rot, or if that rot has been eradicated, there is a valid guarantee which will be transferred to buyers. And in both cases, the language used in Gretton and Reed is really in relation to the next point which they make, and that is that these guarantees, although they may be valid, may be of little assistance, given that the grantor of the guarantee is no longer in business, nor does it extend to adjacent premises. So I think the points that Gretton and Reed are making in both these provisions are actually in relation to whether the guarantees are worthwhile. And I don't think we should read into it that it should be a definitive interpretation of what is meant by infestation. Nevertheless, that appears to be what the sheriff did. So Sheriff Diomedio held that the infestation ought to be construed eustem generis, but did not accept the defender's argument that it should be eustem generis to the words immediately preceding, that is, woodworm, and that it was not restricted to animals or insects. Nevertheless, a structural defect could not be an infestation. So the infestations could only be dry rot, wet rot, rising damp, which I don't think is an infestation of insects or animals. And he regarded them all as infestations. Well, accordingly, he held that it was in contemplation of the parties that Japanese knotweed was intended to be covered. It was, in his words, a harmful thing or matter that could commonly adversely affect a physical building. Now, that seems contrary to DEFRA, a report of 2017, and the research that's referred to in the RICS guidance and standard of 2022. And he doesn't seem to have any factual basis on which to make the conclusion that Japanese knotweed can affect a physical building. And I think that sufficiently taints his decision to result in a successful appeal if the defenders choose to do so. And he went on in the subsequent paragraph to describe things as the entire list of matters was made up of harmful things that could commonly adversely affect a property, and that other infestation meant other harmful infestations that could commonly adversely affect property. Well, for a start, that's a circular definition of infestation as meaning an infestation. And that again seems to me to give a ground for appeal because he doesn't actually address the issue. Nonetheless, Sheriff Remedio held that standard condition 2.1.3 in the fourth version of the Scottish Standard clauses was sufficiently wide to encompass Japanese knotweed. And that is where the decision rests after debate, and no doubt it will require to go to proof thereafter. I now want to turn to the relationship between the standard clauses, version 5, and the home report. And firstly, I want to deal with the property questionnaire. The property questionnaire forms part of the home report required by the Housing Scotland Act 2006 and the Prescribed Documents Regulation of 2008, which prescribes the form of home report and property questionnaire. The Act is silent on liability for any misstatements by the seller in relation to the property questionnaire. So I looked at the explanatory notes for the Act produced by the Scottish Government, and those notes provide that any financial impacts of the home report scheme more broadly relates to costs of the home report being incurred by the seller, but doesn't mention the question of liability of the seller for misstatements in that home report. So I think next we need to turn to one of the leading authorities on negligent misstatement, and that is Caparo Industries against Dickman, 1990, UK House of Lords 2, which was related to the delictual liability of auditors for misstatements. And it proposed a threefold test: foreseeability, proximity, and whether it was fair, just, and reasonable to impose the duty. Now, it's been argued in subsequent cases that there's a fourfold test, but let's just stick with Caparo because it's sufficient for our purposes. There's always an issue about whether fair, just, and reasonable to impose a duty actually gives the court considerable discretion and is utterly meaningless. But let's just stick with it because that's really what the basis is. If we look at Caparo Industries, there was a statutory requirement for a company to have an auditor a statutory requirement for an auditor to produce an audit report. And it was held that where Dickman had relied on that audit report contained in the published statutory accounts of the company, it was a problem of Dickman. There was no liability to third parties. Had Dickman required the auditors to vouch the accounts, it would have been possible to get statements from the auditors and or the directors, but they didn't do so, and there was no liability. So there was a statutory requirement to produce the report for a particular purpose, publishing accounts. Question 13 of the property questionnaire asks if the seller is aware of any specialist treatment, dry rock, wet rock, rising damp, or any other specialist work. It doesn't ask if there's any dry rock, wet rock, rising damp, or other specialist work has been carried out. So other specialist work is subject to this similar problem that confronted the sheriff in Busby, a justem generis, or a more general meeting. Would that, in fact, be sufficiently broad to cover specialists who had carried out removal work for Japanese knotweed? And again, in relation to question 14A6 of the property questionnaire, it asks about guarantees for any other work or installations. And the examples, and they're clearly only examples here, are cavity wall insulation, underpinning, and indemnity policy. So if the specialist company which has removed knotweed has given a guarantee, then again, this would seem to be caught by question 14A. So there could be problems in relation to the property questionnaire. But this is my take on the property questionnaire. It's foreseeable that a purchaser might rely on the property questionnaire. It's proximate that a purchaser might rely on the property questionnaire. But is it fair, just, and equitable to use the Caparo test? There's a statutory requirement to provide a property questionnaire. And if we look at the typical transaction, the seller is a private individual, the purchaser is a private individual. The whole transaction is intermediated through professionals. We have an estate agent who markets the property, or a solicitor estate agent who markets the property, a solicitor who does the conveyancing, and a surveyor who carries out the home report. For the purchaser, we have a solicitor who carries out the home report. We have a mortgage broker who introduces the purchaser to a lender in relation to finance. So everywhere we look, we see professionals who have professional indemnity cover, whereas a seller is unlikely to have indemnity cover for the sort of liability of negligent misstatement. So to my mind, that suggests that applying a Caparo type test, it is not fair and reasonable, nor is it just and equitable to allow the seller to be held liable for negligent misstatements. It might be a different matter altogether if the misstatement is reckless or deliberate, but it would then be up to the pursuer, that is the purchaser, to prove recklessness or actual knowledge of the homeowner, which might give rise to a liability. So the second part of the home report that I want to consider and its relationship to standard conditions version 5 is the single survey itself within the home report. It's instructed by the seller, but of course relied on by the purchaser. So there's no direct contractual relationship, but Caparo principles remain in play. The surveyor carries out the survey for the seller, knowing it will be relied on by the purchaser. It may be in performance of a statutory duty, it clearly is foreseeable it will be relied upon, particularly where there is a mortgage valuation to be passed on to the lender incorporated in the home report, and it is proximate. Surveyors hold professional indemnity insurance for the opinions that they give, and if we look behind the statute, the purpose expressly stated in the explanatory notes is to prevent multiple and wasted surveys. So in my view, the fair, just and proportionate test has been met, and it would be appropriate to hold surveyors liable to a purchaser for negligent misstatements in the home report single survey. If it's fair, just and reasonable and proportionate to hold them liable, then the corollary of that is that it is not proportionate to hold the seller themselves liable. Now, if we look at the form of the single survey, it's prescribed by statute, but there is no reference in the statutory style to Japanese knotweed, and there is scant reference in the form itself to the garden brown pertaining to a property, which is almost entirely focused on the building itself. So I then thought I would look at the terms of engagement for a variety of surveyors. I found the terms of engagement for Janie Shepherd online, and I expect other surveyors have similar provisions in their terms of engagement. So Janie Shepherd provide that expressly Japanese knotweed is excluded from the scope of the survey. Now that feeds back to what I said earlier. If we look at 2.1.3 and the general terms in 2.1, they refer back except as disclosed in the home report. Well, something is never going to be exposed in the home report if it forms something that is out with the terms of the survey. So that to me suggests that 2.1.3 and 2.1.4, or sorry, 2.1.3 cannot refer to Japanese knotweed because surveyors exclude liability from this as being within the scope of their survey. It's interesting, however, that in the RICS guide and the professional standard later in 2022, paragraph 3.1 states members should be aware that standard clauses and terms and conditions of engagement attempting to exclude any liability associated with the presence of Japanese knotweed are unlikely to meet the requirements of the Consumer Rights Act 2015 or withstand scrutiny of the courts. That's something, I think, for surveyors. So if we look at standard clauses, version 5, and look at clause 31.2, the seller confirms that the information contained in the property questionnaire is true. So it's made into a warranty only as far as the seller's knowledge and belief. It clearly is a limited warranty as to the existence of that state of affairs at the time the standard clauses are invoked, which will be in relation to the offer, and presumably that extends until the conclusion of the bargain. So that is extended to the date of the offer by 31.3, but beyond this, there is no future or promissory warranty. And that should bring to mind Winston against Patrick in 1980. Okay, it's 40 odd years ago, but it still is an issue that is reflected in the Scottish Standard clauses. And although Contract Scotland Act 1997 implemented changes recommended by the Scottish Law Commission in their report 3 Bad Rules in Contract the preceding year, it doesn't change the fundamental situation of caveat emptor in relation to sales of heritage in the absence of any future or promissory warranty. So At this juncture, I thought I should say something about the English TA6 form. Now, that is broadly similar in the disclosure of information to the property questionnaire contained within the Home Report. It's non-statutory in England. It has been promulgated by the Law Society of England and Wales as part it regards of its public-facing role rather than part of its role towards the profession. And there has been a degree of controversy about the latest edition of that published earlier this year. Now, the TA6 form, I think, is important because the TA6 form had provision in relation to knotweed before anything was done in standard conditions in Scotland. The insurance clause in the standard conditions about special terms seems to have been lifted entirely from the TA6 form. So you can see that influence crossing over from one jurisdiction to another. In the 2020 edition of the TA6 form, there was reference to Japanese knotweed. And in the 2024 edition, that has been made more explicit to cover Japanese knotweed, not only within the property that's being offered for sale, but also in the adjacent properties around the boundaries of the property. That led to the legal profession in England calling a special general meeting of the Law Society of England and Wales, but the motion of no confidence in the chief executive of the Law Society was lost. So that controversy remains, and the previous edition from 2020 still has force until early 2025. Now, of course, failure to use the forms prescribed by the Law Society of England and Wales may result in charges of inadequate professional service, and it may be relevant in relation to negligence claims as well. So it seems very likely that this broader definition of adjacent properties will take effect from next year. Now, if we compare that with the Scottish Standard Clauses, version 5 in 2.1, we've spoken about this already. So far as the seller is aware, the property, etc., is not affected by. Now, it doesn't say that there is nothing on the property, that there isn't nothing on the property, it's affected by. And I think it's reasonably clear that affected by could relate to adjacent properties. In England, the 2024 version of the TA6 was said to have been influenced by material information in property listings sales, guidance for estate agents, produced by the National Trading Standards Estate and Lettings Agent Team in November 2023. Now, this guidance is said to have been issued under the Consumer Protection from Unfair Trading Regulations 2008. Those regulations, of course, superseded the old Property Misdescriptions Act. And a feature of both the regulations and the Property Misdescriptions Act is that they provided no civil remedy to consumers and only allowed for prosecution by trading standards officers. So I think we should bear in mind what the risk is of not complying with that. And it doesn't really affect the sale and purchase between a private individual and a private individual purchaser. So the key part of the 2008 regulations is that material must be supplied if it constitutes material information, that is information which the average consumer needs, according to the context, to take an informed transactional decision. That's Regulation 6, subsection 3. That guidance produced by the National Trading Standards body applies UK-wide, but there's very little attention paid to the Scottish situation. One of the few examples is that heritable title is said to be the equivalent of freehold in England and Wales. Now, I'm not sure that the National Trading Standards Estate and Lettings Agents team is a statutory body. I think it isn't. So I don't think that this constitutes statutory guidance. It really includes only informal guidance. And I think the trading standards people have really missed a trick, and they don't understand the difference between estate agency and the conveyancing process. One thing is very clear: there is no reference to the statutory home report scheme in Scotland, and in my view, that statutory scheme in Scotland, prescribed in the home report, defines the material information that must be provided. Now, another feature of the guidance is that there is no reference to Japanese knotweed whatsoever. So whether or not that truly was the inspiration for the revision of TA6 in England isn't clear. It certainly has no place in relation to the contract of sale and purchase, as I've said already. So I think we can take away from all of this that Japanese knotweed is a problem. Public perception is perhaps over-egged by the popular press, and it is something which can be treated. Whether 2.1.3 was ever intended to cover Japanese knotweed is surely debatable, but the words "or other infestation" do cause a significant uncertainty in relation to the process as to what infestation might mean. Other invasive plant species in 2.1.4 is equally objectionable on the basis that it's not clear what it covers, and it is perhaps surprising that it does not qualify it to non-native plant species. Furthermore, the idea in 2.1 of affected is something that could extend beyond the boundaries of a property. For example, a property might be said to be affected by flooding when the property itself is not flooded at all, but a public road leading to the property becomes impassable because of flooding. That clearly affects the property, and it's that sort of uncertainty that's created by using the word affected. A simpler form of words, "there is no Japanese knotweed on the property," is much clearer. Conveyancers ought to be drafting for certainty. That's the lawyer's role, to remove doubt in the contract, to remove the prospect of litigation. And I would suggest that the standard conditions, if they're not themselves revised, ought to be qualified, or the whole of 2.1 should be taken out. Now, I've highlighted a variety of sources that you might find useful if you require any further reading. So those are the RICS guidance now professional standard in relation to knotweed and the DEFRA report. There are obviously cases, the Supreme Court case most recently of Davies and the Busby case in Scotland in the Sheriff Court, which suggests some care may be required in drafting qualified acceptances. And for those of you who want to have a fuller written version, then that will appear in the September 24 edition of the Scottish Law Gazette. I hope you found this an interesting talk and it is some use to you in your practice. Many thanks.